Great.
Okay,
Thank you
let's
so
try
much.
that. Thank you. All right, just to try this now. It's the most terrifying part of any presentation, I think, today.
I think so too.
Do you see my slides?
Yes, we do. Thank you. This looks
Fantastic.
great. Please proceed. You
Excellent.
have the floor.
Thank you so much. And thank you so much, Mike, Michael Newman, and the Office of Outer Space Affairs of the United Nations for this wonderful invitation to speak. We just had a coffee break, but it's always very nice to follow my friend Sergio Marquisio, from whom I've learned so much and whom I hope we'll see again very soon. Today, I've been asked to talk to you about Article 7 of the Outer Space Treaty. I see we have approximately, well, more than 150 people online. And so first, I must apologize. I hadn't realized that the schedule was a little delayed, and I will have to present and run. But I'll give you my contact details at the end of this. And of course, Michael will answer the questions you have, but I'm very happy for you to reach out to me as well. I'm a lawyer, so before I start, I will have to say that today I speak in my academic capacity as a professor of law at the National University of Singapore, and whatever I say does not, of course, then engage the other organizations with which I'm affiliated. I've been asked to talk today about Article 7 of the Outer Space Treaty, liability for damage caused by a space object, and also to discuss a liability convention. The specific topic that Mike gave me was the problem of proving fault in outer space. I had a thought about this, and I think one of the things that we probably should say from the outset is the Outer Space Treaty, being an international treaty, is international. And so what it does is it binds countries. Of course, as you might have heard probably earlier in the program already, it's an interesting situation we face today because more and more we're getting a whole plethora of different kinds of actors. So it's not just states that are involved anymore. And so we're going to kind of address that and probe that a little bit when it comes to liability. But when we talk about the Outer Space Treaty and the Liability Convention, they really bind states. And so what we really need is for these states to implement these conventions, either through authorization and supervising mechanisms that you have probably heard already from Article 6, or other kinds of mechanisms when it comes to contractual liability. So we're going to speak about that today. Just quite quickly, the outline of what I hope to discuss today. First, really state responsibility for space activities and that general framework and how that impacts on liability in relation to what we call internationally wrongful acts. Then I'll focus on liability for damage, which is caused by space activities according to the Outer Space Treaty. Maybe touch on liability in the new space economy, the fora for recovery of damages, and how to prove something that is just compensatory. How do you prove liability? And then maybe touch on some contemporary and future issues relating to liability that we might want to consider. So this is famous Hugo Grotius, and he said, and this is a very classical way of looking at it, from an injury caused, there arises an obligation by the law of nature to make reparation for the damage, if any be done. And Grotius gave us basically what is now known as state responsibility for internationally wrongful acts. And that's very classical. What's interesting, of course, is that international space law, from a public international law point of view, is very unique in this regard. And it does do one interesting thing in relation to liability. It makes reparation where damage occurs an obligation, regardless of whether it was a wrongful act or otherwise. And that's actually something that is quite different. We have a very classical way of looking at it. A violation of international obligation generally creates a new legal relationship between two separate entities. The wrongdoing state, or the state to which the wrongful act is attributable, is usually obliged to make reparation. And there is, of course, the injured state, or the state against which the wrongful act was committed, or to which the obligation had been owed or had been breached. And that state then has the right to demand reparation. Now, that's slightly different in space law. When we're talking about liability in space law, we're really talking about liability for damage. And that's somehow taken as a separate component of the features of the responsibility regime under international space law. Now, interestingly, you must have heard this already before. At the time of the negotiation of the Outer Space Treaty, the negotiating states agreed to a very victim-oriented approach in light of what was considered then the hazardous nature of space activities. And so the idea was that the freedom to freely explore space peacefully and to use outer space had to be balanced with the necessity for the reparation of potential damage that such exploration and use could cause. And that, of course, leads us to the very unique regime that I've alluded to. It is the only regime of public international law that differentiates between responsibility of states for national activities conducted in outer space and the traditional responsibility of states to make reparation for damage caused. And it's also the only regime that has something akin to strict liability, in that it explicitly imposes an absolute obligation of reparation on states and on international organizations. So, of course, this is famous Article 7, and I won't read through it, except that it does basically list the kinds of parties or the categories of parties, states, that could plausibly be liable for damage caused. And liability for damage, of course, has a particular legal framework. Um, it follows really Article 7 of the Outer Space Treaty. There's an entire liability convention that was concluded in 1972. And you would have heard mention already of the 2005 UNGA resolution on the application of the concept of launching state. Now, as I mentioned just a little earlier, Article 7 of the 1967 Outer Space Treaty, as elaborated by the 1972 Convention on International Liability for Damage Caused by Space Objects. It's a very long name. We'll call it the Liability Convention. It provides that the obligation to make reparation is binding on what's called the launching state. And that's a term of art. The launching state of the space object that caused that damage. And of course, there are 4 categories of launching states. And that's the state that launched the space object, the states that procure the launch of the space object, the states from whose territory the object is launched, and the states whose facilities are used to launch the object. Now, in practical terms, this definition of the launching state as the entity responsible for reparation in case of damage has caused a few practical difficulties in its implementation. Of course, there is novel technology and international cooperation in launch services, which has severely tested the notion of what a launching state could possibly be. Because, of course, launches today can take place from land territories, but also from the high seas or from aircraft in 2-stage to orbit launch. And so difficulties also arise in the case of a transfer of property in orbit, such as when satellite sale agreements provide for in-orbit delivery. And in such cases, the state with de facto jurisdiction and control over the space object may not actually be the actual launching state. So we've seen already many examples of this, where the delivery of the satellite, for example, is taken on orbit. And that means that the launching state launches it, but thereafter transfers the ownership and presumably the jurisdiction and control over that space object to the customer that takes delivery on orbit. So one of the examples that, one of the examples that we have maybe I think mainly talked about, because we know this to be public. It's a 2007 in-orbit delivery by China Great Wall Industry Corporation on NIJCOMSAT-1. Of course, it was built and launched by a Chinese corporation, and once successfully inserted into orbit, the satellite was then delivered to Nigerian Communications Satellite Limited. So that's one idea that you can have of in-orbit delivery of satellites. Now, aside from that, there's also an interesting complication that has arisen, in particular in some arbitration cases, in relation to the word procurement of a launch. The English understanding of procurement, so the English text, of course, which is an authentic text, has a kind of an idea that it relates to financial arrangements for the purchasing. Whereas, for example, the Russian understanding of the term procurement appears sometimes to relate to the organization of the launch rather than its simple purchase. So, of course, that has led some commentators, even some states parties, to critique the imposition of liability on the launching state. So we've had states who have noted, for example, the unfairness of imposing liability on a state which has only allowed its territory to be used for the purpose. And for all intents and purposes, that space object is under the jurisdiction and control of another state. Of course, there have also been other states that have interpreted the Outer Space Treaty and the Liability Convention to exclude the liability of a launching state where a private space activity or private space actor is involved. Now, this is, however, contrary to the wider interpretation that has been taken at the United Nations General Assembly, and you can see that in its 2005 resolution on the application of the concept of launching state. So we've already heard that we could have more than one type of launching state that could be involved in a single launch. And there, of course, the point simply is that all states are jointly and severally responsible, excuse me, for the damage caused by the space object in question. Now that means, of course, because of the victim-oriented approach, a victim of damage can quite easily find a state that might be responsible for reparation. But it also means that states with unequal interest and participation in the launch are placed in the same position, really, in relation to the obligation to make reparation for any damage caused. And this wide definition might be even more onerous because of the broad rules of attribution of conduct to a state. So we have all these issues coming up, but of course the question is, when we're talking about liability, what liability are we speaking of? And the liability regime applicable really depends on the place in which the damage has occurred. So the Liability Convention provides for absolute liability for damage caused on the surface of the Earth or to an aircraft in flight. However, where the damage occurs in outer space, then the Liability Convention provides for what's called fault-based liability. That is, the victim must show that the damage occurred due to the fault of the responsible state in order to establish liability. So let me say that again. If it occurs in outer space, it is the victim that should show fault-based liability, meaning that the damage was due to a fault of the responsible state. Now, it's quite interesting because the Liability Convention in itself expressly does not apply ratione personae to damage caused by the launching state against its own nationals, or to damage caused against foreign nationals who, as a result of invitation by the launching state, was participating in the operation of the space object or in the vicinity of the planned launch or the recovery area. Something interesting here as well is Article 6 of the Liability Convention, which allows for exoneration from the obligation to make reparation for damage, where the damage resulted either wholly or in part from gross negligence or from an act or omission done with intent to cause damage on the part of the claimant. Meaning you can't cause this damage or be negligent or intend to cause the damage and then claim reparation for that damage. Now, this is the concept of gross negligence, of course, which sets the responsibility regime in outer space quite apart from the general rules of state responsibility. Now, where the damage resulted from activities in breach of international law, however, it's very important, there is no exoneration from reparation that is possible. Then, of course, what damage are we claiming for? What damage is reparable? Liability is restricted to damage caused by a space object. There is no definition in any of the UN texts on space law as to what a space object is, but Professor Bin Cheng has defined a space object as a man-made object that is launched or intended to be launched into outer space. Now, this definition, as implicitly understood in the negotiations leading to the adoption of the Liability Convention, has several implications. First, the definition of a space object includes the launch vehicle, as well as components of a launcher that never enter into space. Second, the definition of a space object was implicitly understood to mean an object having material and physical properties, meaning that objects without such properties, such as, for example, EM waves or electromagnetic waves, are excluded. And the significance of this is that liability is engaged for damage caused by, say, a falling first stage component of a rocket, but liability is not engaged in the case of, for example, service interruption by a satellite-based global navigation system, such as Galileo in Europe. So when we have more and more space-based, Earth-oriented activities like Earth observation and remote sensing, this implicit understanding has now come under challenge. And of course, the third implication that's quite interesting is that damage caused by objects naturally formed in outer space would, of course, not fall under the Liability Convention. So, for example, if damage caused by natural objects, say asteroids or pieces of asteroids, returned to the Earth by sample return missions would also not be covered by the Liability Convention. And that's actually quite interesting as to what comprises reparable damage. I think I've heard mention of it in the very short time that I sat with you on the question of space debris. And what happens if there's damage that could potentially be caused by such space debris? Now, space debris, of course, as you know, refers to all non-functional man-made objects in Earth orbit or re-entering into the Earth's atmosphere, which includes fragments and elements of space objects. And there is some agreement, I think, that space objects, space debris rather, should be treated as component parts of a space object. But there seems to be continuing debate as to whether space debris as a whole would fall within the definition of space object. Now, of course, you've heard mention of the very important 2007 Space Debris Mitigation Guidelines. It has been adopted by the UN, but it also does not define the term space debris. So we're not quite sure there, except to say, of course, that if it was a space object, it would have been covered if damage had occurred due to that space object. That would have been reparable damage. So now, what kind of damage is covered? And the Liability Convention does define that. And the convention defines damage as, and I quote, the loss of life, personal injury, or other impairment of health, or loss of or damage to property. Now, indirect damage, such as the loss of revenue, was not specifically included in the wording of the convention, although there is no restriction, you see, on claims for both material and immaterial damages. So reparation for damage must restore the entity on whose behalf the claim is presented to the condition what's called ex ante, which is the condition that would have existed had the damage not occurred. And this is in conformity with the standard definition of reparation at international law, but also in particular, the Liability Convention specifies that reparation must be prompt, it should be full, and it should be equitable. So then it comes to this question, which is in the title of the presentation today, fault-based liability. And that, of course, it has to do with damage that occurs in outer space. And the idea simply there is that the idea was to protect the planet and protect the airspace and traffic in airspace. And so there was absolute liability for damage that occurs on the surface of the Earth or to aircraft in flight. Anything outside of that in outer space would have been fault-based liability. There are several issues that arise when we consider fault-based liability. And the first, of course, is what exactly is fault? There are two ways to look at it. There's, of course, subjective blameworthiness, so something that is subjectively blameworthy is fault, or there is an objective breach of a legal duty. And either way, there is an issue with one of those ways of looking at fault, because subjective blameworthiness may also then have different standards. An objective breach of legal duty means that there's nothing special in relation to liability for space law versus liability anywhere else or responsibility anywhere else in general international law. Now, that was also not what was required or considered by the drafters at the point of time. The next question, of course, is what duty or standard of care needs to be proven for there to be fault? And that particularly ties into the third question, which is what is the burden of proof? How would one prove culpability of something that happens in outer space? The easy example that you will always hear is when you have, for example, a component of a space object, a non-functioning one, that is classified as space debris. And we have them, big ones, little ones, very little ones. The question is how to tie that then. And that leads into this last question, which is how would one prove causation? How do you tie that piece of space debris or non-functioning space object, or even a space object itself, to an entity to whom you can attribute fault? If it were a collision of two satellites, that's an easy way of proving fault. But today we understand there's right now about 6,700 satellites in orbit. We're expecting the launch of between 70,000 and 100,000 satellites in the next decade. There are going to be many, many satellites. And if there is a collision and there's debris in the debris field, it's going to be very difficult to tie that and attribute fault to one particular entity that you can prove causation to. And of course, the subsidiary question there is, does fault have to be foreseeable? So when you launch an object into space, would you have had to foresee any kind of damage? What kinds of damage would have been foreseeable? If it were not foreseeable, can you prove causation? Does fault then have to be foreseeable? And if so, how? So I just want to touch a little bit on liability in the new space economy, because this conference is about the Outer Space Treaty for the 21st century. And you see a lot of trends in the global space economy, in particular technological advances, of course, with more cost-effective space activities, a lot of increased private investment by investors new to space. And of course, that doesn't take away from the military and strategic importance of space as a very crowded and very valuable high ground. That, of course, trickles down to a realization that commercialization can achieve better, faster, cheaper access to space, but still, it kind of is held in connection with a vision of space as being transformative for humanity, as well as a growing awareness of environmentalism and sustainability concerns which are faced by the Earth and the outer space environment. All this leads to a global economy that is increasingly data dependent, has diverse effects on space capabilities and markets, and has diverse actors that we have to deal with today. In 2019, the size of the global space economy was 344.5 billion. It's expected to increase, really, 2.5 times increase in 20 years, meaning by 2040, the space economy is forecast to be approximately $1 trillion US, and that's quite a large economy. Now, today we hear, of course, a lot about the rise of space startups, and startups could really range from anything. They could do anything from software on board to really manufacturing on orbit to launch capability. There are little startups that get swallowed up by bigger ones. There are also really big startups with a lot of backing. What does that all mean then? We are seeing sectors which are currently attracting investment. Reusable launch vehicles, for example, is one of them. Situational awareness, especially in outer space, what will then lead towards space traffic management and awareness. Space tourism and transport have been around for some time. And now we're, of course, looking to other sectors which attract investment: in space research and manufacturing, small sat and infrastructure platform manufacturing, satellite servicing, and perhaps even resource utilization. And of course, we go back to the traditional satellite applications. We have telecoms, always. Each one of us holds a piece of space in our hands today with our mobile phones. We have direct broadcasting, which we're very used to today, this day in particular, for streaming and internet. The connectivity and the Internet of Things, of course, we're very used to maps and Earth observation being available in real time, in real space. And that, of course, leads to GNSS and location-based services, as well as science, weather, and informational networks that you see in a traditional satellite application. There are also other sectors that I won't go into with a long-term growth potential, but I wanted to give you this overview together with those that are already right now currently sectors that we have in space, because all of this actually does impact on the establishment of fault and on the establishment of liability. For example, in space today, we have the use of satellites, constellation of satellites for quantum communications. It does provide secure banking, but then the question, of course, is that if it's secure, if it's quantum, how will that impact on the establishment of fault? What is foreseeable in the use of such quantum communications? Something else that has come in the last few years is the use of the distributed ledger technology, DLT, or the application that we know as blockchain. That's immutable and completely distributed across the world. And that then gives rise to some questions as to how to attribute which entity do all the entities that touch on this have become attributable for any sort of liability. Imagine you have a space object that has its software or has its intangible assets written on the distributed ledger. And this ledger is, of course, all over the world in different distributed nodes. Does that make every single country, every single state liable for any damage that might occur? I won't go into the others. I just want to touch quite quickly on two things. One is hyper-accurate data provision, which is now having constellations of satellites to have really hyper-accurate location-based services, for example. And that, of course, means that there's very little margin for error. And when we're talking about liability, when it comes to fault, how does that play into the establishment of fault? Would that make the standard too high? And would that then have a chilling effect on the growth of the space economy? The last thing I want to mention is dark skies, because I think I saw a comment in the chat about that. That's quite interesting because it kind of impacts on something that is happening today, which is environmental protection and situational awareness. You will be very aware of a group of very brilliant young people who are basically taking the world by storm because they're taking the world responsible for environmental protection and climate justice. Now, in relation to space, we've just heard Professor Sergio Marchisio speak about Article 9 in due regard. We've also heard a lot about orbital debris and how to then protect the Earth and the Earth environment. Not just the Earth now, but also planetary protection to and from forward and backward contamination, quarantine procedures, and so on. All of this leads to what we call situational awareness. And when we have all of this in place, possibly it'd be easier to attribute causation, and possibly it would be easier to then have a an entity to which you can point to for liability, especially for fault-based. But we then need to have this framework. And hopefully with the conversations ongoing about space traffic management, planetary protection, and this interdisciplinary, interoperable question ongoing for space, we can then come up with a situation that could help not just finding solutions for the public law and public aspect, policy-facing aspect of space and space activities, but also in relation to liability for damage if damage is caused. So just quite curious as well, when we're talking about liability, where are the claims related to liability for damage in space taking place? You know the claims procedure, which I won't go through, you will have slides later, but there is a claims procedure already set out in the Liability Convention, does go through diplomatic channels first, but also is very victim-oriented. So there's a shield against diplomatic protection, and there's no condition on the prior exhaustion of local remedies. So it does, however, prohibit double reparation, but it also then allows the procedure for the setup of a claims commission. And of course, it also allows for claims involving multiple actors. We haven't seen this commission used very often, or at all actually, in the system of space law that we have. We don't know if it's going to be used in the future, but it does exist there. And it's usually for claims between two states under the Liability Convention. You would have heard of the Cosmos 954 incident, which was the only example we are aware of in the public domain. That's in the 1978, the year of 1978, where a nuclear-powered Soviet satellite 954, Cosmos 954, which re-entered the Earth's atmosphere, and it eventually crashed into Canada, scattering debris over the northwest territory of Canada. Now, in that case, Canada presented a claim for reparation to the former Soviet Union, and the claim was based on the Liability Convention, relying also on the general international law for internationally wrongful acts. It was, however, amicably settled, and the protocol on the settlement of Canada's claim, which was concluded in April of 1981, specified neither the legal basis for compensation nor expressly referred to the Liability Convention. So we're not quite sure how it would have gone forward had it gone to the Claims Commission, but that's the only public case that we're aware of. However, there have been several space-related arbitral proceedings that I'm aware of in my own experience, and we see them in various different chambers of commerce and courts of arbitration as well. And these are the four that at least we're aware of that have administered space-related arbitral proceedings. And of course, the next thing that might happen is international commercial courts, and that a state might then be involved or not. And that's where liability is really shifting towards private sector use of space and how that would gel with the public international space law framework in relation to states parties to both the Outer Space Treaty and the Liability Convention. Just before I end, I'd like to take you through issues you might want to consider in relation to the establishment of liability. There are quite a few here, but obviously the ones that we have to consider are the obvious ones, right? So the scientific and technical issues which are specific to the mission, for example, launch windows. We have to talk about the state's international obligations because space law is still the domain of states, this international space law that we are focusing on today. But in relation to that as well, several other kinds of issues have arisen in the last few years in relation to the establishment of liability and fault-based liability. And that has to do with the types of parties to the disputes, as well as private international law considerations. And that really is the conflict of laws issue of what law would be applicable, which forum would have jurisdiction, and how would any decision that's taken be recognized and enforced across borders. The question, of course, for a lot of space missions is whether such cases have a need for confidentiality and whether that's even desirable. What happens if there's potential harm to third parties? And how would one then gel this with domestic legislation, as well as to have any sort of decision and award verified and implemented, in particular if it involves doing something in outer space? So I leave you here with some key takeaways. A lot of arbitrations that go towards liability considerations involve satellites, of course. It's 90% of arbitration proceedings today with various amounts, from little amounts to big amounts. There are existing space-specific evidence infrastructure that might need some improvement. How do we take evidence in space? How do we prove fault? What is the standard of proof? What is the burden of proof? Of course, the disputants are changing. So the bulk of the parties are now commercial entities that either go through their state or by themselves initiate dispute settlement mechanisms. And of course, the question of how would this contribute to the evolving field of law? So how does this relating to liability, including the taking of evidence, the standards of proof, and so on, contribute to other high technology fields? So I will just stop here. This is my contact details. I have given a much more traditional lecture on responsibility and liability with the United Nations Audiovisual Library, and you see that link then in the bottom line of this slide. I'd be very happy to stay in touch with anybody else. And I thank you all very much today for sharing this time with me. Thank you.
Thank you very much, Professor. It is really a pleasure to see you again and to hear you again. Your enthusiasm is catching. We really do appreciate it so much, and your contributions to our work has been immense, and we really love having you. And I know that you have to run, and it's just such a great pleasure to be able to ask you at least one question. And just to recall that you were speaking so much about space situational awareness and information and its usefulness potentially in being able to attribute fault to certain players, especially considering how difficult it is to understand who is doing what and everything. But one thing that I would like to ask, and this goes to the heart of a lot of our progressive development of international space law, where we see the growth of non-binding instruments and this the seminal instrument, of course, on space debris mitigation guidelines. And where we've seen, and we've even heard today from our friends in the Russian Federation, their very strong concern and interest in implementing these space debris mitigation guidelines. And we will, of course, hear from the United States as well in just a bit about how they have implemented these space debris mitigation guidelines in their jurisdiction. Do you think that these voluntary guidelines, when implemented so strongly by states and considered so important by states, could they be, while not establishing a formal duty, could they be nevertheless establishing a standard of care that when departed from, could this be evidence of fault in a way? What are your thoughts on the use of non-binding instruments as supporting a way of determining fault in outer space activities? Thank you.
Mike, I've come to count on you for asking the most brilliant questions and really right on point. And there, if I might, I'd like to give you perhaps two perspectives in answer to that question. The legal perspective, which is, I suppose, even the easy one, is that non-binding standards are still standards. And when put through a forum like the United Nations, it gets to see consistent and widespread state practice. Now, we know, of course, as lawyers, the Continental Shelf decision by the International Court of Justice, and this basically shows us what we need for consistent and widespread state practice by the most specially affected states. In particular, you hear from the Russian Federation, from the United States, and I understand China as well is starting to put this into place. So these really states with direct access to outer space, taking these standards very seriously, meaning that they also then show what we call this horrible thing called opinio juris, that states do this because they think it is binding. That, of course, crystallizes a standard, that standard of proof that we need for fault under customary international law. So that's the legal answer if I had to give a legal court an answer. But the policy perspective is actually quite interesting. In my day job, we talk about this quite a lot. When we talk about conventions versus principles and what soft law is versus hard law. One thing about outer space that we're talking about to cyber, Web3, and so on, that technology. A good example, OpenAI and ChatGPT didn't exist last year. And there really was something that came quite clear. That stands for AI, stands for these sorts of technology to develop quickly, and software allows that. The thing about treaty framework is that to reopen and revise the treaty framework involves, as corrected, so a lot of different procedures. But software allows very quickly working groups to be put together, protocols to be put together, and standards to shift as necessary in this sort of field. So there we'll find a happy medium, and that happy medium, I think, leads us to a good standard when it comes to liability. And you know, having that basic international minimum standard in place already, I think that helps us a lot. I hope that helps.
Oh, you're a bit breaking up for me. I'm very sorry.
Oh dear.
Yes, but if you could just maybe share just that last bit of thoughts with us, would be appreciated. Thank you.
Sure. Do you hear me properly now?
It's.
Oh dear. Okay.
Yeah.
Yeah. I'm having some connectivity issues. Do you still hear me?
You were breaking up a bit. Maybe if you
Okay.
maybe turn off your camera. Maybe it's a bandwidth.
Let's try to hear me better now.
I believe we can hear you better.
Okay, I'm going to try that again.
Yeah.
So just quite briefly, I think two perspectives. From the legal perspective, and I think you haven't lost me at that point of time, under the Continental Shelf decision from the International Court of Justice, what we can do with soft law instruments is to show, especially if it goes through,
Oh, unfortunately, I think now I don't think we can hear you at all. I'm very sorry. This is a product of our modern world, I guess. The benefits of bringing everybody together.
very strongly implemented domestically way, which means that they do this because they believe it should be law. And that gives us the other very elusive part.
Oh, Professor, I think we might have lost you there. Oh, my goodness. Well,
Can you hear me now?
yes, you just came back.
Great. Okay. Great. Did you hear the first part of the answer?
With the
I
continental shelf, I believe we did.
Thank you. Okay. And the second part is the policy answer, really, which is that with high technology in outer space and an economy that moves very quickly, it's actually quite nice to have soft law instruments versus hard law because soft law is very flexible. It's easy to look at, to add protocols and working groups of state representatives that could quite quickly come up with protocols and standards in relation to space activities, technology, and so on. So I think that the policy reasons for having soft law isn't a bad idea either. I hope I haven't lost you there, but I'll
We
just stop
heard
there
that
for another
last, yes.
time. Thank you.
No, but thank you again. Exactly, and we face this in our work in the committee and the legal subcommittee as well, trying to come to grips with the best way to accommodate states' wishes and how they might see their own activities, and to ensure that their activities do not harmfully interfere with other activities of other states. And I think that that is really the core mission of what states are really concerned with, is trying to come to grips with those things and try to find the best way for them to be able to ensure that and to work together and to cooperate. And that's the place that we offer here in the United Nations for states to be able to do that. Professor, thank you again for your spending the time with us, and we really appreciate it very much. And really, we can't wait to see you again.
Thanks so much, Mike. Thanks for having me. And I have to leave
Absolutely.
now. Thank you. Goodbye.
Absolutely, please. Without further ado, we can now move to our next presentation from Miss Melissa Force from Spaceport America to talk about Article 8 on jurisdiction and control, and possibly give us some ideas about potentially shared infrastructure on the moon. We move around quite a lot in discussions on the Outer Space Treaty. Very sorry we're taking so much time and everything, but Melissa, thank you so much for sharing some thoughts with us today. Would you like me to try to share your slides from my side?
Thanks.
Okay, let's see if I can do this. I might not be able to go the full screen with a bit because I've been having some issues, but let's see what I can do. Let's see. Just a moment, sorry.
Oh, that's fine. And thank you for doing the sharing. While you're accomplishing that, thank you for inviting me to be part of this program. It's an amazing lineup, almost all of which I've not been able to see yet because the presentations take place while I'm normally asleep, including this one. But I really look forward to seeing the videos, the recorded videos later after you've compiled them.
Absolutely. Well, I believe I have your presentation here. Please, you have the floor. Thank you so much.
Perfect. Thank you, Mike. Well, as Mike told you, my name is Melissa Force, and I'm the head of the law department for a space launch facility co-located at White Sands Missile Range in southern New Mexico, near the Mexico border of the United States. And I'm going to be talking about Article 8. Specifically, retaining jurisdiction and control through registration of space objects and property rights in facilities and installations on the moon. Next slide. Thank you. So as you know, sovereignty in space is generally shunned in the treaties, except in exceptional circumstances. And one of those instances is Outer Space Treaty, Article 8. And so this first slide reproduces the relevant part for purposes of this discussion of that article. And I'll just read it because I'm going to be referring back to the language numerous times, and it's helpful to sort of get the framework for what we're going to discuss. Article 8 states, a state party to the treaty on whose registry an object launched into outer space is carried shall retain jurisdiction and control over such object and any personnel thereof while in outer space or on a celestial body. Ownership of objects launched into outer space, including objects landed or constructed on a celestial body, and of their component parts, is not affected by their presence in outer space or on a celestial body or by their return to Earth. That is a lot to unpack. And as do most of these provisions in the Outer Space Treaty, they impact other provisions as well and interact with them. Not least of all, when we're talking about on the moon, Article 2, the non-appropriation provision in Article 2, and Article 1, the free use provision, which is very relevant when we're discussing facilities that are constructed on a celestial body. Next slide. So I have put together this little overview. It's basically three parts, three short sections. I tried to not pack too much of the discussion in the short time that we have, so this isn't all encompassing. But my hope, though, is to highlight the broad issues that I believe this subject matter exposes in a legal sense. First of all is the first case, the easy case, where Article 8 permits jurisdiction and control when the facility is comprised of space objects. That's fairly straightforward. We don't have to worry about treaty interpretation here. But the problem is that if an owner wants to sell it on orbit or in space, transfers can be very problematic. And there's some certainty into how to interpret the treaty provisions in the Registration Convention as well as in the Outer Space Treaty. State practice along these lines is going to happen. These are commercial assets. International commercial transactions are going to take place. And the literature is full of states and companies that are trying to the best of their ability, honor the treaty language while also being able to accomplish what they need to accomplish on Earth. And sometimes it's unclear or unspoken in the treaties about what is and what is not permitted. So I'll discuss that in conjunction with on-orbit transfers or in-space transfers. And there are some helpful interpretations that I believe facilitate useful state action. The more difficult case is whether Article 8 jurisdiction is available for facilities, that's including stations, what have you, comprised of in situ resources on the moon. This includes regolith or various minerals that are mined or found on the moon. And one of the big questions is, can it be owned? Can natural resources gleaned from the moon or any other celestial body be owned such that a facility constructed entirely or partially of it can impute the rights that a state would have in a space object performing the same function. And if not, can general principles of law be used to establish ownership so that the same thing can be accomplished in another way? And finally, can authority provided in Article 12 be used to obviate the need to even establish Article 8 requirements in cases where registration is unavailable, either for space, a moon facility comprised of launched space objects, which are the subject of an on-orbit transfer to a transferee who was not an original launching state, or in the case of an in situ construction where it's not clear or perhaps even doubtful that ownership ownership and jurisdiction of the premises is in doubt in accordance with the treaty provisions. Is there a way around that? And Article 12 may be useful in elucidating that answer. Next slide, please. So the first case concerns Article 8 as a basis for jurisdiction and control over a facility. Ownership, jurisdiction, and control follow certain objects after they reach space. This is the easy case I was talking about. Space stations launched from Earth, obviously, or constructed from component parts launched from Earth that ultimately comprise a settlement. So the state's national law, not international law, continues to apply to the object and the people on board. And the state's quasi-international jurisdiction apply therein. But this exception only pertains to a state which both registers and launches the object. International commercial transactions involving ownership can be complicated because of on-orbit or in-space transfers, in the case of a proposed settlement of ownership, and they have unsettled questions. Can registrations, for example, be transferred under the registration convention, or does the language of the registration convention in Article 2 require any transferee also be an original launching state? Looking at that language, that provision states when a space object is launched into Earth orbit or beyond, the launching state shall register the space object by means of an entry in an appropriate registry, which it shall maintain. So the question is, can a new owner be endowed with de jure as opposed to de facto jurisdiction and control in the absence of registration? I mean, the new owner then has, the transferee state has Article 6 responsibilities in accordance with the actions of whatever company or corporation within its state purchased the settlement, or the state, if a state is the operator of the settlement. So there's going to be de facto control necessarily, but can there be a de jure jurisdiction and control if it was not an original launching state? It looks to me like the registration of a space object is linked to its launch, temporally and substantively. The provisions begins with the word when a space object is launched into Earth orbit. That is when the original registration for purposes of this discussion takes place. So it certainly appears that registrations, if they can be transferred, have to be transferred to an original launching state. That doesn't always happen. There have been transfers to states that were not parties to the original launch. Another question is transferee willingness to accept the launching state liability sufficient to affect registration, so that if a registration is entered in the new transferee state's registry with appropriate notice to the UN Secretary General to put everyone else on notice, is that essentially an implied acceptance of launch state liability sufficient to affect registration. State practice on these issues has been inconsistent, and none of these, both in terms of whether to register, whether to provide notice to the UN, whether the state is going to maintain ostensibly jurisdiction and control in the absence of registering a space object. None of the questions have been tested yet, so commercial transactions may have to proceed with uncertainty until they coalesce into best practices or some standard is reached in the international commercial transaction business. Potential claims from lenders under transfer or insolvency may pose complicated issues. Recording and notice systems is notification to the UN Secretary General enough if a lender or creditor can't rely on consistent application of the rule or the process that the transferee followed. And enforcement of commercial interests in numerous jurisdictions may be difficult if the status is ambiguous. And insurance may be expensive or problematic given the uncertainty involved. So one observation that I've had in reading about these issues is that the registration convention requires the original state of registry to be a launching state through a temporal parameter, as I mentioned earlier. When a space object is launched, the launching state shall register it. But the registration convention doesn't say that registrations cannot be transferred to an original launching state or not, or otherwise. So given that there's no rule against it, and if all other treaty provisions are being honored, one could take the position that transfer of a registration, whether or not it's explicitly provided in a treaty, is an appropriate way to safeguard the transferee's interests in obtaining ownership of the object and the other state's interest in transparency into the transaction and understanding of the accurate, timely notice of the new ownership. And if such a practice continues to support key goals of transparency and notice, that process is is not undermined, nor are the treaties. State practice could continue to evolve such that a transferee can register the object to maintain compliance with its new Article 6 responsibilities of authorization and continuing supervision. And Article 8 should not be a problem because jurisdiction and control are only predicated on an existing registration. A state on whose registry, can we go to the next slide? Yeah. A state on whose registry an object is launched is carried. So Article 8 has no temporal parameter. It only requires that the object was launched at some point. So registration could legally be transferred to effect jurisdiction and control in the transferee. But the next case is what I think is a much more interesting case. Can a state acquire jurisdiction and control over a facility constructed of in situ materials? That is the regolith, the minerals, and that's what this slide addresses. Materials that are found on the celestial body, on the moon. I had the extremely interesting and enjoyable experience of being involved in a consortium of actors who were planning just such a construction. And I was very surprised by the extent of knowledge already of what materials are available on the moon, and the process of using 3D printing to fabricate elements that would become in situ formulated habitats. So I think this is something that's worth considering now in the interest of explicating what potential future issues will arise. Article 8 pertains to objects launched, including objects constructed. This presumes that a facility constructed of that the anticipated use was that facilities would be constructed of launched components, or at least it reads that way to me. In situ resources could not be included per se among objects launched into outer space. So registration pertains only to an object launched into outer space from Earth, and accordingly, a state does not have jurisdiction and control over the facility under Article 8 because it was not launched from the Earth and cannot be registered. So what rights does a state have in a constructed facility formed of in situ materials? Natural resources not in place using 3D printing or some other technology. A constructor has arguably a right to inhabit and use it, but can it arguably be owned? And there are some strongly held views on both sides of this issue. I would reference the IISL's 2015 position paper on the subject, which indicates it would not be contrary to the outer space treaty principles, that ownership of resources extracted from the moon could be owned by those who extract them. Perhaps using alternatively general principles of law as a source of international law is another idea. If the ownership of natural resources proves to be insurmountable at some point. Another theory under general principles could be substituted to afford ownership as well. I have here one idea, Roman law of accession through specification, which I've read a little bit about, which involves using skills and labor to create a new product from material not originally owned by the maker to confer ownership of the maker. I've seen arguments, very convincing arguments that that would not work legally, and convincing arguments that that it could work legally. So that's just an area to explore, an alternative to pressing any reliance on being able to own natural resources and certain strong opposition to that position. Next slide, please. So can an owner of a constructed facility, in situ or otherwise, have jurisdiction and control in the absence of Article 8? Current movements aim to remove this uncertainty. You've heard a little about the Artemis Accords by now in the building blocks, specifically building blocks 6 and 8. And I believe this is being discussed in the legal subcommittee working group. Alternatively, might these rights exist independent of Article 8 and its requirement of registration? And here I would just like to propose a look at Article 12. And this, I think, is worth reading. All stations, installations, equipment, and space vehicles on the moon and other celestial bodies shall be open to representatives of other states parties to the treaty on the basis of reciprocity. Such representatives shall give reasonable advance notice of a projected visit in order that appropriate consultations may be held and that maximum precautions may be taken to assure safety and to avoid interference with normal operations in the facility to be visited. Can we go to the next slide, please? So the key point here, I mean, there are tons of ambiguities and potential areas for argument within those parameters that are listed and identified in Article 12. But the key point is that these facilities shall be open for inspection by other states with limitations, of course. The basis of reciprocity, whatever that means. Does that mean a state doesn't have to allow visits as long as it doesn't seek visits? That kind of interpretation might be contrary to the idea of open access to all users of the moon, but it's rather ambiguous what the limits of reciprocity are as they're used in Article 12. And anybody who has a lot of extra spare time on their hands, I invite you to read the travaux préparatoires on the construction of this provision and the arguments the various representatives of the states had concerning all of these provisions, including what reciprocity may or may not mean. Another issue was reasonable advance notice, whatever that means. Confer about maximum protections. And one might wonder, does this confer a right of veto if there can't be any agreement on what maximum precautions means? Assure safety and avoid interference with normal operations. So under that proviso, is a constructive veto possible? Aside from these specific parameters, though, all of which have their ambiguities and uncertainty, the entire provision implies the owner has all the hallmarks of jurisdiction over the facility without explicitly saying it. It implies control ceded by others to the host facility. It implies the degree of access is negotiable. It implies the host's subjective judgments and sensitivities must be satisfied. It implies there may not always be agreement as to the bases for the visit. And can we go to the next slide, please? And there may be a potential result which could be perverse to the rule of free access to all areas. And certainly with what I believe to be the spirit of Article 12, which at its very base is ensuring that others may have access to the facility and see what's going on there, as long as there are no harmful interruptions with the ongoing business. One result could be to deny access if a host is never satisfied by whatever maximum precautions are offered by other states. And it would be relatively easy to slow walk indefinitely reaching any agreement on what maximum precautions could be. Could that at some point result in denial of access, a right of exclusion? Even though Ambassador Goldberg, the U.S. representative during the treaty negotiations, stated subsequently that the agreement to include that second sentence is not to be taken as a right to veto the visit. But an indefinite delay, even if it's not a veto or even if it's not a constructive veto, is still a very high degree of control. And, you know, despite all these uncertainties and ambiguities, I think the key takeaway point from Article 12 is, despite all of those issues, which I believe would be able to be worked through, and I don't expect states are going to be unreasonable in actually denying access. But the point is, there's an unusual degree of control given to the owner or user of that space facility. And that looks an awful lot like jurisdiction and control without having to implicate all the requirements in order to satisfy Article 8, judgment and control. The next slide, please, is my conclusion. So in conclusion, my takeaways are, first, under Article 8, authority easily exists where a facility is comprised of space objects. And this may very likely be the very first wave of settlements when they get underway on the moon or asteroids or other celestial bodies. But on-orbit transfers might be problematic. Another interpretation of the registration convention might support de jure jurisdiction, and I believe it would, and that looks to be the direction that these kinds of transfers are going. And I believe it's in everybody's best interest that transferred registrations are permitted to provide all parties, all states notice of the current status of those transactions. So I believe that the transferees' status as whether they were a launching state of that particular space object would recede, or that kind of interpretation would recede into the distance, given what I believe is going to be the overwhelming usefulness in being able to have clarity and best practices transacting business for on orbit or in space objects. Secondly, Article 8, where the facility is made of in situ resources, an object comprised of regolith or minerals, some natural resource could be owned. I believe that is sort of the direction that opinion is heading, and certainly under the new movements afoot, that appears to be the case, as well with certain legislation passed by influential states recently. Alternatively, general principles of law may be used to fill in the gap of ownership, where it just where ownership isn't clear in terms of treaty provisions. That may or may not ultimately come to pass, the Roman law that I mentioned earlier, but I'm sure there are other general principles that exist as well that could fill that gap. Finally, Article 12 is the only provision in the treaty that I've seen, the Outer Space Treaty, that gives indirectly control over access to a facility. The power to deny entry or to strongly control what other parties see, when they see it, how they see it, their behavior, their conduct is tantamount to jurisdiction and control. And it may not be called that, but in the future, when transfers of such facilities are affected, perhaps the absence of an Article 8 basis will come to mean much less in terms of a transferee's willingness to purchase such a settlement. So that's all I have. Next slide is the end. Thank you very much. And Mike, thank you for asking me to be part of the panel. I appreciate it. It's an honor. And I look forward to seeing everyone else's presentations. Thank you.
Now, thank you very much, Melissa, for sharing all of this. And it's excellent in a way that you mention Article 12. This is, of course, very, very interesting. And it's a very forward-looking article that obviously we have never implemented. And luckily, tomorrow we have a presentation from our good Chinese friend Yu Shu from the Ministry of Foreign Affairs of China, who will be talking about what his views are on how that could look in practice. And he will be making a dive into this issue of reciprocity, into the travaux that you were mentioning, which is fascinating, actually. And this is also in context of our previous, yesterday we had a presentation from from our good colleague in the United States as well, in the Department of Commerce, Gabe Sweeney, an architect of the Artemis Accords, in what his views are in the exploration and use of outer space. And all of these issues, of course, come into play in our working group on the legal aspects of space resource activities. And that is essentially where we are looking into all of these dichotomies in the Outer Space Treaty, which seem to be contradictory in so many ways. I mean, free exploration and use on the one hand, not a prohibition of appropriation on the other, this jurisdiction and control that having flavors of ownership, of course, and then, of course, this open and free access provisions as well, coming to grips with that in the context of multilateralism in the international community. We hope to be able to find a way to square all of these things so that the interests of states can, of course, go forward. I mean, every state that has possibility to engage in space resource activities or indeed exploration activities of the moon and other celestial bodies has an interest in resolving these issues so that they can undertake these activities in accordance with the treaty and in accordance with international law. But one thing that I noticed that you had this experience with this 3D printing of installations on the moon, and maybe you could share just a few short thoughts on how this might look, because this is something we have been thinking about as well in these shared facilities, possibly in shared launch or landing facilities, so that would reduce harmful interference. If everyone has a launch or landing facility on the moon, there certainly will be a lot of moon dust kicked up. Also, potentially shared facilities in power generation, using of course, the peaks of eternal light of the craters of the South Pole, and also potentially in resource extraction and refining. This type of, all of these installations likely will have this type of regolith. What was your experience with in advising those kinds of activities? And can you share some words? Thank you.
Yes. So I love that question, but really it's so out of my wheelhouse. This years ago, when these thoughts were very much in the infancy, even before I joined the spaceport as the general counsel, this was very new, a very new concept. 3D printing hadn't even been around for that long in any kind of realistic sense. So the speculation was really centered on what minerals do we know of on the moon that could be generated as component parts of a shared facility, and I agreed with you, that's kind of how I believe this is going to start taking place. But most of that was not known then. And this is many years ago, but it really sticks with me. My Article 12 was a wonderment to me because it was, it struck me then, and it still does now. It's very, very different from the other provisions. It's probably, you know, an imagining and that the treaty drafters had, and trying to construct rules that users or states would be able to follow and use settlements effectively, while also respecting Article 1 and Article 2 of all parties, not just those states sharing the facility, was very difficult to do. And I imagine that's why those parameters that are identified in Article 12 are like they are. They don't rule anything out, but they provide more than just the mere maintenance of comedy. But they couldn't go too far in restricting an owner's right to control, you know, harmful interference on the premises. And we, at the time, were looking at whether Article 8 would even apply in order to be able to make sure that we could control what was happening there, not hide anything, but there was so much unknown about what processes would take place, and if these were living habitats, would those be susceptible to visits by other parties, and how would that take place? And back then, I was of the opinion, and this has not changed, that Article 8 jurisdiction and control is not what we should be looking at. It's Article 12, which provides, I think, the greatest degree of control in a settlement, which may not be made of component parts of launched objects, but very likely at some later point in the future, in situ materials. So
Yes.
I hope that answers your question.
Yeah, it does. And I thank you so much for sharing, of course, all of these perspectives. And I think that we have an opportunity, of course, to use these to further international cooperation and potentially find a way that we can have mechanisms that facilitate all of these provisions. We're trying to, of course, come to grip with this in our working group to understand the nature of ownership of resources extracted from celestial bodies, and to try to find a way that these activities can really take place. And of course, this will involve this in situ resource utilization and constructing of habitats. And it's just fascinating to see that, we've seen this in the development of the Outer Space Treaty and this forward thinking. And indeed, so much of our community is influenced by, science fiction, and maybe this kind of science fiction and forwards looking maybe will come to pass, and it probably will, considering these recent developments of all of these different players with all of these different interests in going pretty much to the same place, the South Pole of the Moon, at least to start. And so with that, I'd really like to thank you again for sharing today and for contributing to our conference. I really also want to apologize for taking so much time from our last speaker, who I really want to invite, our speaker, Mr. Eagle from the Federal Communications Commission, to share some words. I'm sorry to have taken so much of your valuable time, but your contribution is, of course, incredibly important to our work. Maybe you heard earlier our contribution from Roscosmos, from our good colleagues in the Russian Federation, about their interest in space debris mitigation guidelines and Article 6 and implementation of supervision and authorization and continuing supervision of states, this obligation under Article 6. Sir, thank you so much for joining and sharing how you handle these matters in the Federal Communications Commission and how the U.S. government sees these obligations under international law. This is extremely interesting for all of us. Thank you, sir.
Thank you for having me. Very, very excited to be joining you. Greetings from Washington, D.C. For our first very cold spell that we've had so far this fall, winter, but excited to talk to you about the work that we're doing, specifically from the perspective of the FCC in this space.
Let's see if I can go ahead and share your screen here. Let's see. Oh, goodness. For some reason, it is blocked. Do you see it?
I do not see it. Let me see if I can share.
Would you be so kind? I noticed that there was an intellectual property issue that came with mine, where I was able to see it on my screen, but unable to. I see you have it from your side.
Yes.
Thank you, sir, and sorry about this, a little bit of a glitch. Please, you have the floor. Thank you so much.
Great. Thank you. Thank you, Michael. I will be speaking, first of all, thank you very much to the Conference on Space Law and Policy for having me. I'm Loyani Gal. I'm the head of enforcement at the Federal Communications Commission. And so I'll be able to talk to you about licensing in this space and how we at the Enforcement Bureau ensure that those statutes and regulations are complied with. So a little bit of overview with regards to FCC enforcement. The U.S. Federal Communications Commission was created under U.S. law by the Communications Act of 1934, which means that next year it will be 90 years that the FCC would have been in existence, which, I am in awe to think of how much this agency has been responsible for as a regulator. And I am humbled to think what the person sitting in my seat 100 years from now, the issues that that person will be having to address. Historically, enforcement at the FCC was performed within each of the subject matter bureaus of the FCC. In 1999, the commission consolidated the enforcement functions across the FCC into a single bureau, which is the Enforcement Bureau. And the Enforcement Bureau.
I'm sorry to interrupt. Maybe if you could just maximize your window there, that would be perfect. And I'm very sorry to interrupt.
Does that work?
Yes.
Like this.
Yes, that's perfect, sir. Thank you. And again, sorry for the interruption. And
okay. No worries. And can you see the PowerPoint without any obstruction?
Yes, we can now. So we can read the words on it. Thank you, sir.
Excellent. All right. And so the FCC, the Enforcement Bureau, ensures compliance with the rules and regulations established by the FCC across various sectors, including satellite, wireline, wireless, and broadcast communications. The Enforcement Bureau has the authority to investigate complaints, resolve potential violations of the Communications Act and the FCC's rules, regulations, and orders. It also has the authority to conduct investigations by, for example, issuing what we call letters of inquiry and subpoenas to conduct audits, inspect licensee and/or operator facilities, and collect information. The Enforcement Bureau is also responsible for serving as trial counsel in formal hearings before administrative law judges, mediating and settling disputes between parties, and coordinating with other federal, state, local government agencies, as well as international counterparts on enforcement matters. The Enforcement Bureau plays a critical role in upholding the FCC's regulatory framework by focusing on issues that touch on consumer protection, privacy, data security, cybersecurity, and supply chain integrity, national security, public safety, emergency services and harmful interference, and fraud targeting critical FCC-funded and administered programs. And in also trying to ensure that there's fair competition and equal opportunities and access to communication services. The Spectrum Enforcement Division of the Enforcement Bureau is the primary group responsible for addressing satellite licensing and operation investigations. And enforcement is one of the several aspects of the FCC's role in supervising space communication activities. The U.S., so now we'll go over the U.S. FCC license and space debris law overview. A satellite license is required for deployment and operation in the United States by a non-federal, meaning non-government operator. The FCC's newly created Space Bureau, which was previously the International Bureau, administers the licensing program on behalf of the FCC. Under Section 301 of the Communications Act, no person shall use or operate any apparatus for the transmission of energy or communications or signals by radio, except under and in accordance with this chapter and with a license in that behalf granted under the provisions of this chapter. Similarly, from a regulatory rule implementation of that statute, Section 25.102A of the Commission's rules states that no person shall use or operate apparatus for the transmission of energy or communications or signals by space or Earth stations except under and in accordance with an appropriate authorization granted by the Federal Communications Commission. There are three types of licenses for satellite operations: amateur, experimental, and regular, or what we refer to as Part 25. All three of these kinds of licenses require submission of information concerning radio frequency and orbital technical parameters, an orbital debris mitigation plan, and draft ITU filing materials. Part 25 and experimental licenses also have application filing fees, and Part 25 licensees must pay annual regulatory fees. The materials that are reviewed to determine whether operations would be in the public, the materials that are submitted as part of these applications are reviewed to determine whether the operations would be in the public interest. Licenses often include conditions, including conditions requiring that operations must be consistent with what is described in the submitted information. It also includes specific operational requirements. And there are many aspects of satellite licensing and operation that this presentation will not discuss, but we welcome inquiries to the Commission's Space Bureau for any questions you may have outside of this presentation. Now, multiple federal agencies in the United States government regulate the commercial space industry based on statutory authorities that were enacted separately and have evolved over time. The Federal Aviation Administration, FAA, licenses commercial launch and reentry vehicles, in other words, rockets and space planes, as well as commercial spaceports. The National Oceanic and Atmospheric Administration, NOAA, licenses commercial Earth remote sensing satellites, and the FCC licenses commercial satellite communications, while the National Telecommunications and Information Administration, NTIA, which is part of the Department of Commerce, is responsible for the federal government's use of frequency. The Departments of Commerce and State also license exports of space technology. So this presentation will primarily focus on orbital debris. Orbital debris will be an increasing problem as the number of satellites launched increases. For me, as an enforcement person and a non-expert in this space, no pun intended there, many years ago saw the movie Gravity, and that was interesting, and you looked at it as sci-fi, and to think that that's an issue that we're currently dealing with and is of great import just emphasizes why this is an area of priority for the Commission and for the Enforcement Bureau. So as stated in the July 2022 National Orbital Debris Implementation Plan from the Executive Office of the President of the United States, quote, "The consequences of not mitigating, tracking, or remediating orbital debris could render certain orbital regimes unsafe or unusable for satellites to operate. Thus, U.S. leadership in space entails a responsibility to promote a safe and sustainable space environment for future generations." The Commission adopted a rule in 2004 that a satellite system operator requesting an FCC space station authorization must submit an orbital debris mitigation plan to the Commission regarding spacecraft design and operation with its license request. The Commission also adopted requirements concerning the post-mission disposal of Commission-licensed space stations operating in or near the two most heavily used orbital regimes: low Earth orbit, LEO, and geostationary Earth orbit, GEO. Under Section 25.283A of the Commission's rules, unless otherwise explicitly stated in their authorizations, geostationary orbit space stations at the end of their useful life must relocate to an orbit with a perigee whose altitude is sufficiently high that the spacecraft will not re-enter the region of the geostationary arc plus 200 kilometers. This precise minimum is determined based on a formula that takes into account the spacecraft's physical characteristics, area, mass, reflectivity. This minimum perigee requirement does not apply to space stations launched prior to March 18, 2002, but such satellites must nonetheless have an approved plan for disposal. LEO satellites were required to be removed from the LEO region within 25 years of the completion of their mission. And all space station licensees must ensure, unless prevented by technical failures beyond their control, that stored energy sources on board are discharged as part of the disposal process. One second here. So in April 23rd of 2020, the FCC comprehensively updated its rules for orbital debris mitigation plans. The updates included requirements that applicants qualify collision risk, probability of successful post-mission disposal, and casualty risk. Requirements for disclosures on maneuverability, trackability, identification, and information sharing for situational awareness. This aligned with the 2019 U.S. Government Orbital Debris Mitigation Standard Practices, ODMSP, for federal space stations to ensure consistency for federal and non-federal satellite operations. Further notice of proposed rulemaking sought comment on calculation of total risk for larger constellations, maneuverability requirements, post-mission lifetime, indemnification, post-mission disposal bonds. The FCC adopted a new 5-year rule in 2022 for LEO satellites. GEO satellites remain subject to the aforementioned Section 25.283. As stated by FCC Chairwoman Rosenworcel, the new rules will mean more accountability and less risk of collisions that increase orbital debris and the likelihood of space communication failures. The new 5-year rule requires all space stations ending their mission in or passing through the LEO region below 2,000 kilometers in altitude and planning disposal through uncontrolled and atmospheric reentry following the completion of the mission, to complete disposal as soon as practicable and no later than 5 years after the end of the mission. Grandfathered satellites, satellites already in orbit are exempt from these new requirements. Satellites to be launched after September 29, 2024 must comply with the 5-year post-mission disposal requirement. For any applications granted involving space stations that would exceed the 5-year limit, those space stations would need to be launched prior to September 30th, 2024. In some cases, already authorized systems may require approval of a modification to update their license to reflect alterations in system characteristics to achieve compliance. As such, any licensee or grantee with a license or market access grant which requires modification should file an application for a modification regarding satellites to be launched after September 29, 2024, no later than March 29, 2024. And so the area that I oversee, which is the enforcement, will give a little bit of overview of what we've done related to satellites, and then get specifically into the enforcement action that we recently took with regards to orbital debris. So starting in 2018, we entered into a consent decree with Swarm, which had deployed without a license and unauthorized operation. The Enforcement Bureau found that Swarm Technologies had violated the Commission's rules related to unauthorized satellite operations when it deployed and operated 4 small CubeSat two-way communication satellites, which it called Space Bees, without an FCC license. The terms of the settlement that we reached with Swarm Technologies included ceasing all unauthorized operations and seeking proper licensing for future deployment and operations, payment of a $900,000 civil penalty, $900,000 civil penalty, and a long-term compliance plan for unauthorized deployment and operation of satellites, unauthorized operation of Earth ground stations, and other unauthorized operation and testing of radio frequency equipment involving 4 satellites and 2 Earth stations. The FCC also released an enforcement advisory to the greater industry, alerting the sector that compliance with satellite licensing requirements is mandatory. In 2019, the Enforcement Bureau entered into a consent decree with L3 Harris, which was focused on operation of on a wrong frequency. L3 Harris had sought an experimental license for a briefcase-sized satellite called HSAT-1 in 2016. Thereafter, L3 Harris transmitted on an unauthorized frequency band outside the authorized range, resulting in 324 instances of unauthorized transmission over a 13-day period. There was no harmful interference to other licenses, and HSAT operated within its authorization during the communications to the ground station. The terms of that consent decree included a payment of a $100,000 civil penalty and the implementation of a compliance plan. And now the DISH consent decree, which we entered into earlier this year for failure to deorbit to satisfy license requirements. That consent decree involved a $150,000 civil penalty, admission of the violation by DISH, and a compliance plan for failure to properly dispose of EchoStar 7 at the satellite's end of life as required by the terms and conditions of the license. Little background on this case. DISH was authorized in 2002 to deploy and operate the EchoStar 7 satellite at 119 degrees west longitude to provide satellite TV services to its subscribers. It was projected to have a 12 to 20-year lifespan, meaning an operation period from between 2014 to 2022, up to 2014 to 2022. In 2010, DISH filed for a modification to operate the satellite permanently at 118.8 degrees with an orbital debris mitigation plan requiring the satellite to be moved to a disposal orbit at least 300 kilometers above its operational geostationary orbit after completion of its mission. DISH calculated and agreed to reserve 11 kilograms of fuel to get the satellite to its end of mission orbit. In 2012, DISH again filed for and was granted a 10-year extension, which extended the term of the license, including the orbital debris mitigation plan, from 2012 to 2022. In 2022, DISH informed the FCC that while attempting to maneuver, the satellite was running low on propellant. DISH was only able to place the EchoStar 7 satellite at a disposal orbit of approximately 122 kilograms above the geostationary arc, well short of the orbit specified in its orbital debris mitigation plan incorporated into its license. DISH's failure to place the EchoStar 7 in its disposal orbit was in violation of the orbital debris mitigation plan, which was part of its approved license. The Enforcement Bureau found violations of Section 301 of the Communications Act and Section 25.102A of the Commission's rules for failing to meet a license term, namely the failure to maneuver the EchoStar 7 satellite per its orbital debris mitigation plan to a disposal orbit at least 300 kilometers above its operational geostationary orbit, and that it would reserve, factoring in fuel gauging uncertainty, adequate fuel for this task. As a commission licensee, DISH was required to operate its satellite under the conditions set forth in its January 24, 2012 authorization, including its orbital debris mitigation plan, but failed to do so. So the implications of DISH's unlawful conduct was that EchoStar 7 was approximately 22,000 miles above the Earth and moving approximately 7,000 miles per hour and no longer under control. Moving or refueling the satellite under these conditions is not currently practical. Although the risk presented by a single satellite that is disposed too low is relatively small, risks accumulate with each failure. Consequently, it is important for the operators to properly execute debris mitigation plans. As I mentioned earlier, as part of the settlement that we reached with DISH, DISH paid the $150,000 penalty and admitted liability for violating its license terms. It agreed to a rigorous compliance plan to address the issues that led to the inadequate disposal, including ensuring best practices in propellant tracking and engaging a third-party expert in order to ensure that similar issues do not recur. Specifically, DISH agreed to develop and improve upon propellant tracking using manufacturer-recommended methods for tracking and relying on a third-party expert, develop and improve upon end-of-mission disposal planning, and improve satellite disposal planning. Principles from this consent decree put other licensees on notice that the FCC takes space debris matters very seriously. Failure to satisfy license conditions, including orbital debris mitigation plans, will be enforced by the FCC. And as part of enforcement, one of our principles that we adhere to is deterrence, both specific in this instance with DISH and general for others who are similarly situated. And so with that, that is the end of the presentation, and I hope it was helpful for you to better understand how we've approached this issue.
Mr. Eagle, I really want to thank you so much for providing this incredibly valuable. This is the first time we've ever heard any kind of presentation in this kind of way, showing this type of enforcement action and these conditions of licenses and how the United States, and also this is very informative for other states about how they can understand their obligations under the international treaties and implement these in their national regulatory framework. Mr. Eagle, I know you're very, very busy and you have to step out just now. Your colleagues were telling me. Thank you again, sir. I won't be able to give you any questions, but believe me, your contribution is extremely valuable to our work, and we really appreciate it. Again, thank you, sir.
Thank you, Michael. Pleasure joining you. Take care, everyone.
Absolutely, absolutely. And just with that, ladies and gentlemen, I can tell you that we are really in an interesting place right now where we can see that national regulatory frameworks are important for states to implement. And you can see through Mr. Eagle's presentation the level at which they have issued licenses, the level at which they have responded to, kept up with their supervisory duties, supervisory authorities. And what I find most intriguing and in a way, one of the most valuable aspects of this was this notion of providing notice to other players that these, that this could happen to them, of course, if they don't abide by their license conditions. And these other notions of third parties that can be used to also support the understanding of states and of the way the third parties can provide information to certain commercial operators. For example, in this propellant tracking, there near the end, this also third parties in understanding space situational awareness. This also is what I would consider very interesting as a way to incorporate various data providers, commercial data providers, even into that licensing and oversight mechanism. Again, I would like to thank the FCC for their time, Mr. Eagle for his time. in sharing this with us. This enforcement action is related, of course, to the space debris mitigation guidelines. We saw how those guidelines were implemented in the national regulatory framework of the United States, and their oversight mechanisms really provide a lot of interesting insight and potential guidance to others in this regulatory field. I very much hope that I'll be able to continue, and we can also benefit from more interaction with the FCC in this regulatory role. We are working very hard with states in our project on the Space Law for New Space Actors program, which is headed up by our good colleague Rosanna Hoffman, who will be giving a presentation tomorrow, and on the consultation mechanism under Article 9. But this is really at the heart of understanding what obligations of states are under Article 6. We heard from our Russian friends in Roscosmos their interest and their dedication to implementing space debris mitigation guidelines in their private sector industry that they have as contractors for their work, and for all of the sale and transfer of their equipment out of the Russian Federation to their partners, that space debris mitigation guidelines are implemented in their construction here and in their operation. Here we also have a very interesting insight into implementing space debris mitigation guidelines at the construction, at the way of implementing the planning, implementing in licensing applications, that there must be a space debris mitigation plan. We heard this is an interesting way and instructive way that these states have tackled this issue under the Outer Space Treaty. This could be also looked at by other states that possibly could be looking into getting into space activities, possibly licensing the manufacturing of space objects in their jurisdiction, how they might go about some of that oversight, how they might go about putting those requirements into their national frameworks, how they might go about enforcing those through their courts and administrative systems, and also making this as what we also heard, that there is a relationship between the risk posed by such space objects and the debris mitigation plan, of what that might mean in the future, this cumulative effect, this understanding that these space objects they could pose a hazard, they could pose a danger to the activities of other states. This could expose the liability of those launching states and of those states having jurisdiction over those operators in the international setting. So this, I believe, was a very interesting perspective and a very useful contribution to our Space Law Conference, especially under Article 6. This is a seminal article nowadays that is coming into use so much more. We heard about all of the developments in the new space activities realm from our good colleague, Ms. Escalar, earlier, very vibrant recounting of our possibilities in outer space. And now we see what that means in practice, and to be responsible state actors under international treaty obligations. This has been an incredible day. We have heard an incredible amount of views from numerous colleagues, academics, scholars, practitioners, government officials. We started the day off with security, and we ended with regulation of commercial space activities. It's an interesting travel under the Outer Space Treaty. We are incredibly blessed that we had this breadth of speakers. And I really want to thank all of the presenters for giving their time today and to spend time with us and share these views. It's been really an incredible ride. I want to thank all the participants for tuning in and hearing these as well. And be prepared. We have more tomorrow. We're going to dive deep into Article 9, Article 10, 11, and 12. This is we have so much to cover in so very little time, and I really want to thank you again for staying all the way. We're an hour over schedule as usual, but it's impossible to cut off such great content and information. Thank you again, everyone. Look forward to seeing you tomorrow, and have a great evening, afternoon, or morning, wherever you are. Thank you.